bit of the sniffles. I apologize. I'm recovering from a...
No problem. And if you need to get some water, feel free. If you put it right there, I have no problems with that. That may help.
Pollen is killing me. I'm just...
I thought I escaped it this year.
It makes me cranky, so look out.
Okay. Good morning, ma'am.
Good morning. Kendra Parris on behalf of the Appellant DTM. And I'd like to reserve 3 minutes.
Very good. You may proceed.
So the Risk Protection Order Act, the new 790-401, is unconstitutionally vague as it's currently written, and it's an unlawful delegation of legislative and prosecutorial authority. That is not to say that it was not passed with good intentions. It was passed with the best of intentions. Directly after Parkland, it was passed in somewhat of a hurry. About 3 weeks later, we had the Marjorie Stoneman Douglas Act. But the Florida Supreme Court, in upholding the first DCA in Dallenbert v. Anderson, noted this point, that political popularity and good intentions cannot save an unconstitutionally vague law. In fact, they said, we are especially sympathetic with laws aimed at safeguarding the public. Nevertheless, we may not allow our sympathies to interfere with the constitutional rights of those members of the public who are affected by the statute. The United States Supreme Court has made it clear that the clarity with which a law must be drafted depends on whether or not it threatens to impair a constitutional right. And here we do have a statute that clearly impairs a constitutional right, that is the Second Amendment right, under Heller and its progeny.
Let me ask you this, since we're talking about the U.S. Supreme Court. In Johnson versus United States, the court stated, as a general matter, we do not doubt the constitutionality of laws that call for the application of a qualitative standard such as substantial risk to real-world conduct. And it quotes, the law is full of instances where a man's fate depends on his estimating rightly some matter of degree. So bearing that language in mind, that quote in mind, can you explain to me the qualitative difference between significant danger and substantial risk?
Well, substantial actually has a pin-downable meaning to it. Significant has been, we've got both federal courts that have explicitly stated the term significant is inherently ambiguous. You can't cite to, for example, Hagan, which held it stood for the unsurprising proposition that just because a term is undefined in a statute, that doesn't necessarily mean that it's unconstitutionally vague. The problem here isn't necessarily that we have an undefined term with significant danger. The problem is that the term significant is inherently ambiguous. It can mean one of two things. We've got the term clinical significance, for example, meaning just enough to be noteworthy, just enough to be noticeable. And then you've got the word significant meaning something to me, like a great deal, a lot. And so whether it means just enough to be noticed or a whole bunch is unclear from the terms of the statute itself, and it's not defined anywhere in the Florida statutes. It's not clarified by case law or common law or trade usage. So what you've got is a list of 15 optional criteria. The court doesn't have to look to any of them. You could have a situation where somebody actually ticks off some of those criteria and meets some of them, but still doesn't meet the actual standard, which is whether somebody is a significant danger based on any relevant evidence. Nobody knows what the term significant means in these cases. In fact, I would argue that what the courts are actually being asked to do is just look at whether somebody's a danger simpliciter, because nobody knows what that term significant is meant to imply. If anybody's a danger based on any relevant evidence, then we're going to go ahead and grant the risk protection order.
And you don't think we should look at, and I know you've indicated that it's kind of vague, but you don't think we need to look at its plain and ordinary meaning, what significant is?
Well, the plain and ordinary meaning, like I say, is inherently ambiguous. It can mean one of two things. It can mean enough to be noteworthy. And I don't know how a court is supposed to reliably and objectively apply something that means there's a noteworthy danger, as opposed to, like, for example, the first DCA in the Jefferson Davis case, they actually addressed the issue by sidestepping it and saying, well, we looked at the dictionary definition, and it just means noteworthy. I don't know how that provides any further guidance than the word significant does to the court. doesn't mean noteworthy, or it doesn't mean a great deal, because the legislature did not clarify that. And so you have these 15 criteria that are completely optional, but even if some of them are checked, the ultimate standard is whether somebody's a significant danger based on any relevant evidence. And that's not just a vagueness problem, that's an unlawful delegation of legislative authority. This is the same language that the Supreme Court of Florida struck down in Barge, I'm not sure how it's pronounced, but Sarasota County v. Barge. You had a special act creating the Minnesota Key Conservation District, and in that particular law, it was prohibited to do anything that created a significant environmental damage. And the Florida Supreme Court said, you didn't define significant. We have no idea how this law is supposed to be applied evenly. And they struck down that law as unconstitutionally vague. You have to read that case in coordination with Askew versus Cross Key Waterways, which came about 5 years later, and the Florida Supreme Court there said, we've got the same language. Again, you've got a statute that allows an administrative agency to designate areas of particular state concern. And
in this situation, the legislature just didn't stop and say significant risk. They gave some suggested criteria. Don't those criteria sort of inform the meaning of the word, you know? So evidence that the respondent is seriously mentally ill and has a recurring mental health issue, a recent act or threat of violence by the respondent against himself or herself or others. So the legislature has kind of laid out, this is kind of the stuff we're talking about, and that's what significant means.
Well, one could argue that that's what most courts are doing, but the plain language of the statute doesn't make that clear.
If the court, you know, what would be the standard of review of the issuance of one of these?
Whether or not there was competent substantial evidence, which would be a de novo review, just like a domestic violence injunction, I would say.
Would we, a de novo review to find what, whether the judge, I would suggest perhaps the judge would have or would not have abused his or her discretion.
Oh, well, it's
would these factors be factors in that assessment?
They could, but again, the statute says you may consider these criteria. You don't have to.
Of course. And and I submit to you that if a judge issued one of these and didn't consider any criteria, that judge might get reversed because the issuance of this thing was an abuse of discretion.
But that's potentially the case. But again, like if you look at SQ, which came around and looked at the same language that was struck down, the significant environmental danger. They said, you know, we're going to strike down this law for other reasons, but we're not concerned with this term significant now. And the reason we're not concerned about it is because we've got the protections of the APA in place. This is pursuant to a delegation of legislative authority where we've got an administrative agency that can clarify what we mean by the word significant. We have no rulemaking authority in Chapter 790.
But that's far different. I mean, what is an environmental impact? Here, to follow what Judge Northcutt said, you're looking at a statute that explains significant danger of what? Not in its isolation, of causing, and it says personal injury to himself or herself, and then it goes on, or others, by having in his or her custody or control, or by purchasing, possessing, or receiving. So it does go on. So it's not in isolation like the other case that you're referring to.
Well, I don't know that there's really a distinction because it all gets back to this term significant danger, which really I think is unfair to the courts because in every last case what they're being called on to do is make an I know it when I see it determination. We think based on our gut determination that this person is potentially a significant danger, whatever significant danger is supposed to mean. But we have no rulemaking authority. Law enforcement agencies are not agencies for the purposes of rulemaking authority. So we're getting no clarification, no procedural protections from the APA. So we're in barge territory where the Supreme Court made it very clear. And in fact, I would argue that because we were only talking about environmental issues and not a constitutional right in Barge and Askew, that the Constitution demands even more clear language here than it would in an environmental statute. And so, again, it's because of the vagueness that we have an unlawful delegation of legislative authority. In fact, I would say this is what the legislature did. They said to the courts and law enforcement, Go find the dangerous people and take their firearms away. And we're going to give you a lot of words in this statute that give the illusion that we're giving you a clear standard, but we're not. We're saying if there's significant danger to have a firearm, take their firearms away. And of course, in law enforcement respond, well, on what standard are we supposed to do that? If there's significant danger. And we're not going to give you a definition of significant danger, by the way, either. And then the courts say, well, what are we supposed to look to determine if there is significant danger? Any relevant evidence. I'm not going to tell you what's relevant. We're going to give you a list of 15 optional criteria, but you go ahead and figure it out on your own. That's an unlawful delegation of legislative authority, particularly where we have no agency that's actually explaining what these terms are supposed to mean. And going back, Judge Northcutt, to what you were saying before, the term serious mental illness isn't defined anywhere. Even the listed criteria are themselves vague. There's no definition of what a mental health issue is supposed to be. It's not professionally used in any sort of mental health context. What's a mental health issue? Nobody knows what that means. There's a definition of mental illness simpliciter within the statutes. There's no definition of serious mental illness within the Florida statutes. We have to assume that term serious was included for a reason, but we don't know what it's supposed to mean. So even if you're going by the criteria, you've got a lot of vagueness in there too. If you go, there are about 4 that include the term threat. Threats of violence. Some of them, actually none of them include any scienter or mens rea or intent to communicate a threat. Some of them don't even require that the threat be against an actual individual. You could read those terms and say if somebody says something like, I'm going to kick your dog, that would be grounds to meet one of these criteria. Is it enough to make somebody a significant danger with a firearm? I don't know. But going back to the idea that the clarity with which a statute needs to be drafted depends on whether or not it impairs a constitutional right, there are ways that they could have made this statute much more constitutional. They could have created an imminency requirement. The alleged danger can't be maybe 6 months from now. It's conceivable, hypothetical. Maybe somebody's going to commit violence down the road, so we're going to take their firearms away for a year. The Connecticut statute actually requires that the alleged harm be imminent. The Connecticut statute requires that the person who's being subjected to a risk protection order actually own a firearm in the first place, which is not the case in Florida. We've been taking these out against many people, including children, who can't possess or purchase firearms anyway under Florida law. Are we really getting a public safety benefit out of that? So we could tighten it up by requiring that the law, that there be an imminency requirement, requiring that people actually own a firearm in the first place, and getting rid of this mental illness requirement, which Connecticut doesn't have either, because we're not asking for anybody with actual mental health experience to come into the court and testify, yes, this person has a diagnosable mental illness. We're relying on the lay testimony of the police and lay observations of the judge. It's not a mental health adjudication. I don't know why it's in there. We have the Baker Act for a reason, where we've got recent examination and actual mental health criteria that are built into the law to safeguard due process. When we're alleging that somebody is mentally ill, has a serious mental illness, or a recurring mental health issue, that's...
As I hear your argument, I know you're arguing it's unconstitutionally vague. You do agree that there's case law out there that says just because a statute fails to define its term does not render it unconstitutionally vague. But some of the arguments that you're making, isn't it more of an argument as applied challenge?
No, I would say that this is a facial vagueness challenge because in every last case, the court is called to make this significant danger analysis. They're not going by the list necessarily. They're figuring out every last time, is this person a significant danger to have a firearm based on any relevant evidence? That's what's being called of every single RPO judge in every last case. It's unconstitutional in every one of its applications. But I would also argue that a facial vagueness challenge is applicable here because we're talking about a law that impairs a fundamental constitutional right. That's the Second Amendment. It also has implications when it comes to the First Amendment. If you look at the Booters case, actually, this was a Florida Supreme Court case that upheld the constitutionality of the stalking and harassment statutes. And they said that the reason that these are constitutional is because it explicitly excludes constitutionally protected conduct. The statute itself says this shall not apply to constitutionally protected conduct. It requires that the threat be malicious and willful, and it requires that the threat have no legitimate purpose. You've got none of those protections in the Risk Protection Order Act law. With all 4 of those threat criteria, there's no scienter, there's no mens rea, there's no requirement that it be an intentional threat or a credible threat under Florida law or a true threat under federal jurisprudence. And then finally, it is absolutely inappropriate for the legislature to designate police as the prosecutors in these cases. For the final hearing, there's a reason that the state attorney works on the Baker Act cases. It's on behalf of the state of Florida that the Risk Protection Order Act is obtained, Because what we're trying to do with the risk protection order is protect the public writ large. The remedy is not obtained on behalf of Polk County. It's not like somebody can move and then have a firearm over in Lee County. The remedy is obtained on behalf of the state of Florida. The state of Florida is actually the real party in interest, which is why the state attorney should be the one who's actually bringing these cases to the court. This is a violation of Article 5, Section 17, which says that the prosecutor shall be the prosecuting officer of all trial courts. Now, I realize these are civil in nature. So are Baker Acts. We're not talking about a regular civil proceeding here. We're talking about a proceeding where somebody's fundamental constitutional rights are at stake, just as with the Baker Act, and we're talking about a state actor making the petition. And those circumstances, with these narrow civil cases where we've got much more at stake than replevin or specific performance, we're talking about a fundamental right at stake, and you've got a state actor who's making the petition, those have to be taken to the court by the state attorney. I don't know where I am with time, but...
You're at 15 minutes right now.
Okay.
But with a domestic violence injunction, as you point out, that doesn't have to be brought by a state attorney.
But sorry.
Go ahead.
Domestic violence injunction is obtained, it's a remedy obtained on behalf of the person who's bringing the petition. It's for their own safety. I'm only doing this because I want myself to be protected. In certain situations, I want my child to be protected. That's not what's going on with an RPO. It's either brought pursuant to the parens patriae power to prevent the person from harming himself.
The DVI, the judge could require the respondent to turn in firearms.
Right, but that's blanket in every last DVI case. There's no discretion from the judges. Every last DVI results in...
Fundamental right.
Yes, but that's a blanket determination by the legislature. We're not going in case by case and saying, oh, in this case we think you're a significant danger, in this case we think you're not. That's where the problem comes in from a due process standpoint.
Does it matter to you that 790.4012A says that a petition for risk protection order may be filed by a law enforcement officer, a law enforcement agency? It's not mandated that that's the only agency, the only entity that could file the petition. Does that change your analysis at all?
It does require that law enforcement, the may there is actually saying you have the discretion to file these or not if you think that the circumstances warrant it, which is an even bigger problem from a due process standpoint. You've got pretty unfettered discretion on the part of the police to determine, we're going to go ahead and bring an RPO here.
They are the only ones who can bring it?
Yes, Your Honor.
Do you want to save the rest for rebuttal?
Sure.
Very good. Thank you, ma'am.
Good morning. It's been a while since I've appeared before this honorable court for oral argument, so it's a pleasure appearing. My name is Mario Cabrera. I represent Grady Judd as the sheriff of Polk County, Florida. First off, this statute is not unconstitutional. Of course, there's recent case law that just came out 2 weeks ago from the First District Court, which this court obviously does not need to follow, but it's persuasive. The statute itself, if you look at the plain language of it, puts a person on notice as to what conduct is forbidden. The statute clearly states that if you commit a dangerous act with a weapon, that this act could come into play in which law enforcement could file a petition to take away your right to be able to bear arms for a year. The argument...
But it's not just if you commit a dangerous act with a weapon. It doesn't only apply in those circumstances.
If you make a threat to commit an act as well. Yes,
or
you're correct.
If you pose a significant danger.
Yes, that's correct.
Personal injury to himself. And you're giving specific examples of where it could apply from the non-exhaustive list. But those, I think the point is, those aren't the only situations in which it could apply, and therein lies the danger, because there's nothing in this statute that prevents this from being applied arbitrarily or capriciously.
The statute says that basically you have to be able to pose a significant danger to yourself or others. It sets out factors which the court can look at in making that consideration. Most of the factors which are set out are acts. three of the factors, which one of them is mental health, that the court can consider. It clearly states that in these acts, if you commit one of those acts, the court can consider actually granting a risk protection order.
But I think the concern is what happens when you don't commit one of those acts. What if you do something else? And how do you know if that something else is encompassed within here when you're not talking about a clear-cut situation, but where it's not quite as clear? What in here gives you guidance to determine when it's clear enough?
And that has to be based on a fact-specific basis. That's why the Act requires that law enforcement file an affidavit along with the petition setting forth the facts for the court to consider and look at. The Act, again, requires that these petitions be set for hearing within 14 days, and also requires that the opposing party be given due process and service of the petition personally, and that they have the opportunity to appear before the court to oppose the petition and to present their own arguments to the court. There's due process protections in the Act itself that eliminates misusage of the Act by the fact that you have to make, the law enforcement has to investigate, they have to file these affidavits, they have to talk to witnesses. They just can't blatantly file a petition that has no bones to it to be able to support it. We feel that the argument that the appellant is making is an as-applied argument. The problem with an as-applied argument in this case is that she's not disputing that the behavior of, that his behavior, the appellant's behavior, doesn't fit the criteria of the Act or the statute. The argument that the Second Amendment is being violated by the statute is also, as it's been presented in Hagan, which states that, you know, the right to bear arms is not an absolute right. It can be restricted by government. And also the fact is that there's, in Hoffman, that if you're making a argument that is outside an argument under the First Amendment, you have to also, it's very difficult to be able to say that a statute is facially unconstitutional unless you make an argument that the evidence that presented in that particular case, the facts, do not fit the statute. You can't argue that someone else's behavior is what you're considering. And I believe in this case, without us having a record, it's very hard to be able to determine an as-applied argument. This case sets out, or the statute itself sets out, that it also, if the court grants a petition, the respondent has an opportunity to go back to court within that year to be able to have the court reconsider the facts, and for the court to actually could, at that point, after reconsideration of the facts, set aside the risk protection order. So there are safe grounds in the act, in the statute itself. We're not talking about deprivating someone of their right to be able to have guns. It's only for a temporary purpose of a year. And the statute itself, it was basically, and it's set forth out in Davis versus Gilchrist Sheriff. The purpose of the statute was because of all the violence that's occurring in schools and in the general public, especially gun violence, is to be able to curb that threat from occurring before it happens. This is a very straightforward argument. The statute does not give us any legislative authority for law enforcement to do anything or for us to be able to interpret it or misuse it in any way. It also doesn't give us any prosecutorial authority. We're filing a petition with an affidavit to be able to give the courts an opportunity to consider whether or not there is a viable threat.
So it's like an arrest warrant for firearms,
It's
basically.
a good analogy, yes. It is that would be a very good analogy to it.
Because the ultimate decision maker will be the trier of fact to make a decision under the statute whether or not that statute has been violated in any way.
That is correct, Your Honor. All we're doing is presenting before the court the facts and letting the court decide whether or not the facts fit the purpose of the statute. It's just like any other case. It's, again, all we're doing is being able to, like in a domestic violence situation, be able to intervene and be able to circumvent a egregious action from occurring before it does. For these reasons, we think that the statute is constitutional and that the court should uphold it. Thank you.
Thank you. Thank you, Mr. Cabrera. Okay. Actually, Ms. Parris, you have your 3 minutes rebuttal, all right?
Thank you, Your Honor. This is a facial argument, and the reason that we're arguing that it's facially unconstitutional, going back to what I was saying before, is because in every situation, the court is tasked with determining whether or not the person is a significant danger every last time. We never really pinned down exactly what my client was alleged to have said, whether it was get somebody, hurt somebody, kill somebody, shoot somebody. The court settled on shoot. We're not arguing whether or not, we're not arguing facts from the trial court. What we're arguing is that in every case, even if you've got one of these boxes ticked, you're still determining, here, we've got a 16-year-old autistic kid who had a verbal outburst in school. Is that what the legislature intended? But if you are going to, take up an as-applied challenge, and I don't think you need a complete record to do this, I think that this law is unconstitutional as applied to minors. You get no public safety benefit out of it whatsoever. It doesn't pass the rational basis test. There are two things that the risk protection order can do to enhance public safety. Number one, it allows law enforcement to go in and take the firearms that the person already owns. We're talking about a kid. He didn't have any firearms for them to take. Number two, it puts them on the list, basically what in the NICS system, so they can't go and purchase a firearm through a licensed firearm dealer. He was already prevented from doing that too. So they got nothing out of this risk protection order. Basically, they were batting around the mouse. And what they argued is that, well, we're trying to make sure that the parents lock up the firearm. Well, if you go into subsection 7E1 of the statute, it doesn't force parents to lock up firearms if their kid is subjected to a risk protection order. All it says is that you've got a pinky promise that you put your guns away. And Florida already has a safe storage statute. It's 79174. You're supposed to keep your firearms away from your kids. So they had that without the risk protection order. There is no rational basis for getting one of these against a child. You get nothing out of it whatsoever. You certainly don't get the purported interest that the government has claimed exists here. And then I would also say, it's not just an arrest warrant, because you've got the general counsel of the police agency coming in and having a full-blown evidentiary hearing, putting on the case to the court where somebody's constitutional right is at stake. They are acting as many prosecutorial agencies. It's inappropriate under the Florida Constitution.
Well, they do that with forfeiture cases, don't they?
Yeah, but that's legal fiction against an individual piece of property. It's the difference between law enforcement going in to take an individual piece of property and law enforcement going in to take away your right to own property writ large. And that's the difference in those sorts of cases. It's the same with the animals in distress statute that was cited by Appellee. Animals are, at the end of the day, one piece of property, and it's got a local effect too. So it would be appropriate for police in those situations to go in. That's not the sort of situation we've got with the Risk Protection Order Act hearings. And I would say, at the end of the day, right, what makes a statute unconstitutionally vague is that it doesn't set standards for conduct. Well, if you look at this statute, the standard that's set forth for everybody's conduct is don't do anything that anybody could make anyone think that you're a significant danger. Now, what that conduct is exactly isn't specified, not with a non-exhaustive list of criteria.
So your position is, regardless of the investigation, regardless of the evidentiary hearing, regardless of the due process protections that counsel identified, it doesn't matter if at the end of the day you don't know what exactly the findings and conclusions are that you're supposed to make.
Right, if nobody knows what significant danger means, if it's a gut check call by every court every time because this standard is not defined, and the statutes could define it if they wanted to define significant danger and give the courts a little bit more guidance, it could be defined as something like, if you don't grant this RPO, it is more likely than not that in the next, that in the immediate future somebody's going to be hurt. They could put a definition in there and clarify the statute, and they have to, because there's an enumerated constitutional right at stake. For those reasons, I would ask that the court find that the statute is unconstitutionally vague and an unconstitutional delegation of legislative and prosecutorial authority. Thank you.